Order. This event is part of the American Society of International Law's Global Engagement Series, and we're very grateful to our sister society, the European Society of International Law, for having enthusiastically joined us in this effort to deepen connections between our societies, but also between the international law communities in North America and Europe and beyond, of course. Almost a century ago now, in a slim novel, which was initially published in a German newspaper, the writer Erich Maria Remarque wrote, "The first bombardment showed us our mistake, and under it, the world as they taught it to us broke into pieces." English-speaking readers know this book as the famous anti-war novel, All Quiet on the Western Front, but it is actually its original German title, Im Westen nichts Neues, literally translated as Nothing New in the West, that seems tragically prescient for our time today. It is now nearly a month since the invasion of Ukraine, the first casualty of which has been the unimaginable human tragedy and suffering that we have seen unfold in Ukraine. But it has also resulted in a splintering of the global international order that as we knew and understood it. So where do we go from here? To discuss this question, it's my privilege to welcome our distinguished panel for today. Given that all of you are already quite well known to our audience, and I would also want to maximize the time that we have to hear from you, you will forgive me for being parsimonious with your biographies. We are joined by Tess Bridgman of the Rice Center for Law and Security at NYU, Emanuela Chiara Gillard from Chatham House, Christian Tarms from the University of Glasgow, and Judge Gana Jutkivska of the European Court of Human Rights. The judge will be joining us a bit later because she's in another meeting. But we will begin by asking the panelists a series of questions, and then we'll have some time for audience questions. So please do use the Q&A function button that's there in your functions, and we can collect some questions for the end. But perhaps we start with some big picture questions at the beginning, which is by now it has rapidly become evident that the invasion is a stress test for the global political and economic order. And maybe we can tease out a bit more systematically where some of you, our panelists, see some of these most significant impacts. So perhaps we begin with you, Tess. What would you say are some of the major geopolitical and institutional shifts and continuities that we've seen so far, and what can we expect to see in the future?
Well, first, thanks so much to Aysel and Ijil for convening this panel. I'm very much looking forward to hearing what my colleagues have to say, as well as the audience listening. And obviously, it's a set of questions that continues to evolve. So hopefully we can provide some benchmarks to begin to think about these questions. This audience is, of course, very well aware that this is the type of aggression that our international order most abhors. Conquest and annexation are incompatible with the principles of territorial integrity and sovereignty of states. Regime change runs afoul of principles of self-determination. Our entire modern collective security regime stands for the proposition that borders can't be redrawn through force. So these, of course, are the biggest challenges to those bedrock principles that we've seen in the post-World War II order. That said, we've seen a really unprecedented response to Russia's odious actions as well. So whether it's the UN General Assembly vote, where you had 141 states in favor of condemning Russia's actions for the precise reasons just outlined, whether it's the unprecedented costs imposed on Russia already by a wide array of states, not just the US and the EU, but led by the US and European partners. And we've also seen signs that as those costs are being imposed and even as the war grinds on, some international institutions are continuing to function in ways that we would hope. My colleagues will tease out more about the international judicial system, but just to quickly note, we saw even at the Security Council, which is of course hopelessly deadlocked on the issue of the present war, we saw the renewal of the UN political assistance mission in Afghanistan. We saw the extension of sanctions with respect to Yemen. And we've even seen, despite some, I'd say, rather large hiccups, that prospects for revival of the JCPOA, the Iran nuclear deal, may still be alive. So I think it's far too soon for a postmortem of the post-World War II order, as it were. But we have, of course, already seen some shifts and will, of course, continue to see more. So let's try to put just a little bit of frame around some of those. One that may be the most clear and certainly of note for our audience here today is a major shift in terms of support for international criminal justice in general, the International Criminal Court in particular, and even towards states prosecuting crimes of aggression, which is something, of course, we haven't seen recently. So, first, in terms of the US view in particular, there's been a huge shift with respect to the recognition that even where likely defendants of an ICC investigation, prosecution, are citizens of a state that has not accepted ICC jurisdiction, it's still appropriate to support the effort of the ICC to seek justice in that situation. Here, Russia, of course. So this is, a case where perhaps the U.S. has been vulnerable to its own perceived inadequacies in the past, and it may be that this shocking moment is enough to get them over this hurdle. We've also seen, of course, a much broader invigoration of support beyond the U.S. As soon as the prosecutor called for referrals from states parties such that he could immediately commence an investigation, 39 states jumped basically overnight to provide referrals. And of course, we've seen the shift towards states as well, attempting to begin prosecutions, at least investigations of aggression as such, as well as crimes against humanity and war crimes. I think Poland, Lithuania, Spain, perhaps even others already have opened investigations focused on aggression. And this is a really notable shift. Another shift that I think is quite clear already, and that we only need to touch on briefly because it is really straightforward, is the renewed focus on defense cooperation architecture in the West, accompanied by shifts in national defense priorities. So unifying NATO, igniting new states to potentially seek membership in the short term. These are very significant steps that may not have happened without, likely would not have happened without Russia's invasion. Likewise, Russia's invasion has spurred even Germany to start, commit more than 2% of its GDP to defense spending. So that ramp up is something that, again, we likely would not have seen without this full-blown war of aggression. And in that sense, we've seen Putin turning his worst fears about the international security architecture into a self-fulfilling prophecy. And that's something that I'm sure we'll see continue to unfold so long as this war continues, but could have a legacy that extends well beyond that. More broadly, this set of challenges, I think we can highlight as being consistent with the trend over the past several years, not just in the time since the 30 days since the invasion, of states and collective security institutions shifting their focus and their orientation towards great power contest and away from counterterrorism and threats from non-state actors, which of course are still there. And those concerns remain present, and states and security institutions continue to work on that set of issues as well. But this could be a moment where we finally start to see, and following the US withdrawal from Afghanistan, where there was already momentum in this direction, we could start to see real efforts to wind down CT-focused wars and essentially move beyond this post 9/11 moment that we've been stuck in for almost 20 years now. I think it's unfortunate that we're seeing that evolve because of other major wars, as opposed to a recognition that it was time to get off the permanent counterterrorism war footing. But it still could be a legacy that we see from these events. And it's, of course, too soon to tell exactly how that will bear out. In the too soon to tell category, we also have a couple of other things that I'll highlight briefly. One is on the UN system in particular, an accelerated potentially decline in our ability to use, in particular, the Council, but likely other UN mechanisms as well, on a range of issues, coming at a time, of course, when we have emergencies on our hands that the global community needs to be dealing with. So from the climate emergency to addressing norms of responsible state behavior in cyberspace, to the ability to cooperate in other conflict areas. We've seen, even of course, well prior to this current crisis, council gridlock over Syria, repeatedly over Myanmar, over Ethiopia. That's likely to only get worse as the US and Russia, and indeed the West and Russia, and potentially with China on the sidelines, unable to get to consensus on those core issues. Perhaps even less predictable, we could see major upheaval related to the economic impacts and blowback from sanctions and from the severely disrupted Russian and Ukrainian economies, gas prices, food costs, the inflation that's expected to get worse, disruption of supply chains. All of these things could have serious knock-on effects in the global South, as well as in wealthy nations that are subject to their own domestic political turmoil right now. So will those dynamics feed into a rising tide of authoritarianism and populism? Or could we see rallying around democracy, the effective support to Ukraine and the need for free peoples essentially to band together to defend against that authoritarianism incursion, even in the face of these economic troubles? Will that tide of support for democracy to be able to hold on? I think that's a major variable. And one final one that I would highlight is, of course, the posture of China. So will it continue to tilt towards Russia? Will it stay on the sidelines and try to keep a low profile, which itself, of course, raises issues with respect to whether it is tacitly supporting Russia's ongoing aggression? If Russia becomes a global pariah truly and stays in that kind of posture, it's harder and harder, I think, for China to have the close ties with Russia that would truly enable it to support its aggression. If China wants to be a major geoeconomic power, it has to have some sort of functional relations with the West. So it's too soon to tell how those shifts will play out, but those are a few that I would highlight that we'll, of course, keep our eye on as this continues to unfold.
Great, thank you. So that's quite a lot of continuities and trends, as you pointed out, but also some shifts, and then possibly also some ruptures and some fairly significant ones. And of course, one sort of major rupture, perhaps at the regional level, has been the Council of Europe and its actions, with Russia being suspended from the Council of Europe. We do have a historical precedent for that from the 60s when Greece left the Council only to rejoin after the return of democracy. But perhaps I can turn to you, Judge Yudkivska, for some context for the Russian case, and how would you expect to see things play out vis-a-vis the Council of Europe and Russia?
Yeah, thank you very much, Neha. Yeah, just that's exactly the point I wanted briefly to address at this round. Yes, well, last week, as you know, the major in the history of Council of Europe event happened. Russia ceased to be a member state of the organization after 26 years, and its flag was solemnly removed from the building of the Council of Europe. Well, interestingly enough, last year, the same date, beginning of March, Russia celebrated 25th anniversary of its membership. Yeah, that was a celebration. And on this occasion, the Russian Foreign Minister Lavrov already, again, within the framework of exchanging of congratulations with the Secretary General, he already expressed a kind of dissatisfaction that was obviously prompted by the previous exclusion of the Russian delegation from the PACE in 2014 following annexation of Crimea. And in particular, he stressed that the PACE should refrain from imposing non-consensus documents and that the activity of the European Court of Human Rights should be free from political and ideological basis. That's he said 1 year ago. While it's worth reminding that the governments that have signed the European Convention, including Russia, have declared their commitment to fundamental freedoms, which are the foundation of justice and peace in the world. 26 years of this document in Russia did not bring neither to Russia nor to the rest of Europe, neither peace nor it bring justice to the Russian citizens. So Just 1 year after this jubilee, the events took place quite rapidly following the invasion of Ukraine on 24 February. The Committee of Ministers unsuccessfully asked Russia to immediately cease all the military activities and decided that Russia committed the serious violations of its obligations under Article 3 of the Statute of the Council of Europe and suspended Russia from its rights of representation in the Council of Europe in accordance with Article 8 of the Statute of the Council. And here is important to mention, the Statute of the Council of Europe distinguishes between voluntary withdrawal from the organization at the initiative of the member state, and Neha just brought the example of Greece, it's Article 7, and cessation of membership against the wish of a member state by decision of the Committee of Ministers, Article 8. In the first scenario, a member state notifies the Secretary General of its intention to withdraw, and the withdrawal takes effect at the end of financial year. Again, it was a case of Greece. Article 8 of the statute stipulates that if member state does not comply with the request to withdraw made by the Committee of Ministers, the committee may decide that it has ceased to be a member of the Council as from the date the committee itself determines. So Russia submitted the withdrawal request, obviously accusing other member states for destruction of the Council of Europe and the common humanitarian and legal space in Europe. In the words of Foreign Minister Lavrov, let them enjoy each other's company without Russia. Nevertheless, despite again they submitted the withdrawal request, by the resolution of 16 March last week, the Committee of Ministers, having noted that the Russian withdrawal request and its intention to denounce the European Convention on Human Rights, decided in the context of the procedure launched under Article 8 of the statute, again, not Article 7, not voluntary withdrawal, that the Russian Federation ceased to be a member of the Council of Europe as from 16 March 2022. Now, what does it mean for the obligations under the European Convention of Human Rights? By virtue of Article 58 of the European Convention, the high contracting party that ceases to be a member state of the Council of Europe remains a party to the convention for 6 months coming, meaning in our case until 16 September 2022. So that's the most probable scenario. That's how the court is exactly today is asked to interpret Article 58. The decision is not taken, it will be taken, but it looks likely that Article 58 is to be interpreted in this way. Now, it means that the Russian Federation remains responsible for acts or omissions capable of constituting a violation of the convention, provided that they occurred before this day, before 16 September. And the key question for us, what we should learn in principle from this experience, that's the main topic of our panel. Yes, Russia is the first state ever expelled from the organization. Yes, we just mentioned the Greek example. But the huge difference is not that the Greece withdrew by itself and Russia was expelled. No, it's not the main difference. The main difference is that in Greek case, it happened after the coup d'etat, when military junta came to the power. In our case, Russia's regime had not changed for past 20 years. So the Council of Europe observed this growing evil, so to say, and the question is how much we were able to do. And this is, again, it's for our further reflections on this topic. I quite often quote Erich Posner, who said that the European Court of Human Rights had presided over a term of authoritarianship to Russia. He said this many years ago. Now, what is actually meant? You know that the question of Russian expulsion, potential expulsion, was raised in the Parliamentary Assembly of the Council of Europe in 2000, during the Second Chechen War. Then in 2008, during the invasion to Georgia. Then in 2014, during the annexation of Crimea. And again, each time it was raised, but then the issue died. And each time the counter argument was, well, we should not leave this Russian citizen, 140 million of Russian citizens, without the protection of human rights. And when the parliamentarian delegation of the Russian Federation to the Council of Europe was sanctioned in 2014. They did not participate in the work of the assembly, and you might remember great debates in this respect. And then again, the question of Russia's withdrawal or expulsion was raised. And then the PACE received a letter signed by a number of human rights organizations arguing basically that for Russian people, the European Court is the last hope for justice. And they assured that thousands of decisions of the European Court had a significant positive impact on the Russian legislation and judicial practice. Now you see what happened today. So 3 years later, the Parliamentary Assembly, which also examined the issue, last week, it considered that, sorry, the positive impact was not so significant to consider Russia as a state truly committed to the European Convention of Human Rights. We were happy when we were observing how Russia complied with the decisions of the European Court of Human Rights. We were happy maybe with a quantitative ratio of implemented decision. It was high enough. Russia implemented a lot. But we did not want to see, maybe that's again, it's an issue for a lot of further reflections. Maybe we failed to see that the crucial non-enforced decision of the Strasbourg Court were actually the decision which touched upon the very essence of the European Convention and the very essence of the democracy. Disproportionate use of force by the state, electoral fraud, all kind of problems with peaceful assemblies, with freedom of expression, so on and so forth. Mass violations of rights of people during the Georgian War in 2008, mass violations of human rights in Crimea. And obviously, the tragedy of the victims of human rights violations in Russia is not that they will no longer be under the jurisdiction of the European Court, but that they have the authorities they have. But again, where was the point of no return for relationship between Russia and the Council of Europe? I believe we will all reflect a lot, and maybe again it's a good lesson for us, and not it's a terrible lesson, but it's a lesson for us to learn. And I think in the second round, I will say, if you have a possibility, I will talk a little bit about the interstate case, Ukraine versus Russia, pending now, and the interim measures applies. Thank you.
Thank you for that, and also for that very wise observation that it's very hard to know when a tipping point is reached and how do we evaluate a tipping point. But it also shows you just how difficult it is for an institution to actually decide on an expulsion or an exile, which is one way of isolating a state. But yet another form of isolation, moving tax a bit, is to boycott or to sanction a state. And right from the outset of the invasion, we've seen a military war, of course, but we've also seen economic warfare in an attempt to bring in an end to the invasion. Emanuela, you're the expert on this economic warfare, including sanctions. Could you walk us through the contours of this economic war that we see playing out?
Thank you very much. And as you say, the international community has been looking for ways to put pressure on Moscow and also Belarus, short of providing the support that would or could be considered as use of armed force and therefore bring them into the conflict. And as you say, one key way has been by the imposition of an extremely broad set of sanctions. And I'm not going for a moment to attempt to map them out here. The restrictions really came very fast. They were very varied in terms of what was prohibited, the number of designated persons and entities, the number of states that have been adopting them, even Switzerland has adopted sanctions. Some of these measures build upon the measures that were adopted by, for example, the EU and US and UK since 2014, and other measures relating to Belarus. Others are new measures, and they are still expanding, still developing. So a couple of reflections, and perhaps in my first intervention, I think it would be useful to zoom in on the basis, the legal basis as a matter of international law for the adoption of these broad range of measures. For evident reasons, the UN has not adopted sanctions. So what we see are autonomous sanctions adopted by the EU and a very significant number of states. What is the legal basis for doing so? And this dimension hasn't really received that much attention. So to the extent that the various sanctions measures do not themselves violate international law, they are a form of retortion, an unfriendly act, but not per se a violation of international law. This could be recalling ambassadors, termination of voluntary programs, travel bans, or restrictions on import and exports, where no obligation to allow imports and exports exist. What about other measures? To the extent that the sanctions and measures adopted do themselves violate international law, so certain freezings of assets, certain restrictions on trade, where trade was required as a matter of law, I think we can consider them as an exercise of collective countermeasures in response to a violation of a preemptory norm of international law, the prohibition on the use of force. Their objective is to induce the state vis-a-vis they've been adopted, Russia, Belarus for the support, to comply with their obligations, their own obligations under international law. Now, ordinarily, countermeasures are adopted by the state that is injured by the party against whom sanctions are imposed. So usually countermeasures are a kind of bilateral relationship imposed in response to a violation of international law. The concept of collective countermeasures foresees the possibility for other states, for third states to do so too, in response to a breach of an obligation owed to the international community as a whole, an erga omnes obligation. Now, I think there is no question that on this occasion, we are dealing with a violation of a preemptory norm of international law, the prohibition on the use of force. So it is a very interesting exercise in the use of sanctions as a form of collective countermeasures. What are the limits to it? Well, first, we need to identify the violation, the rule that has been violated, and here it's the prohibition on the use of force. And then collective countermeasures, such as the sanctions that have been imposed by the EU, by the US, by individual states, must meet a proportionality requirement. They must be commensurate to the injury that has been suffered, taking into account the gravity of the international wrongful act and the rights in question. So are the measures, are the range of sanctions that have been adopted, and here we've got financial sanctions against designated individuals and entities, travel restrictions, suspensions of landing and overflights, significant trade restrictions, and extremely significant banking sector, financial sector restrictions. Are they commensurate with the gravity of the international wrongful act that they're responding to, that they're trying to put an end to, the invasion? Probably. And the truth is, the dust really is still settling. I think all of us are trying to analyze precisely what the range of measures is and what their actual impact on the ground is. They do appear to be targeted in nature against particular individuals, entities, sectors. They're not comprehensive sanctions. What is their impact going to be on populations in Russia, population in Belarus, as others have hinted, the reverberating effect in other countries well beyond? I think we just have to see to determine that. But at present, proportionality requirement appears to have been met. And then a follow-up reflection, it is a very complex number of restrictions that have been imposed, and we've got to be careful to draw a distinction between these sanctions that have been adopted by states and the EU and the measures that have been adopted by private commercial actors with the same objective of expressing condemnation and inducing Russia to comply with its own obligations under international law. Many private operators have suspended their operations in Russia or with connections to Russia. It's important to understand that these are not governed by public international law. They may be a violation of contractual arrangements, but really need to be considered under very different framework of analysis.
Thanks for that, Emanuela. And of course, it's a healthy reminder that the law doesn't drop out just because it's economic warfare. It's still within the remit of the law as to how we judge these actions. But speaking of the law, which is where we've seen the main international law organ for the maintenance of international peace and security been paralyzed, which is the Security Council. But we've seen another war front open, so to speak, which is the war front of diplomacy, where we've seen a diplomatic win for Ukraine in another forum, which is the General Assembly. Christian, what is your take on the war that's being fought on this in part international law, part diplomatic front?
Thank you, Neha. Well, is it a war? I mean, I think compared to the images we're seeing on television, maybe we should be happy for those wars, in inverted commas, to be fought rather than the real ones that we're seeing return. Now, in the General Assembly that you mentioned, I think there are various international institutions in which controversies are taking place. Now, many of you have mentioned already that the obvious body within the UN, the Security Council, is also a site of contestation, but not one that we can look for urgent, decisive action, because in the setup of the Security Council, Russia enjoys the veto power and can block urgent, decisive measures, and has, at least in one case, done so. There are gray areas to the debate, but I think it's broadly agreed probably that if we're looking for an organ that imposes decisive action, the Security Council will not fulfill that role in this crisis. So the attention has shifted to the other big UN organ, the General Assembly. And the General Assembly has taken what in the diplomatic war, in inverted commas, or opposition or juxtaposition probably has been, perhaps with the exception of the ICJ order that I think we may come to speak to, been the most high profile individual instance of a positioning. And that's the adoption of ES 11.1, sort of an oddly named General Assembly resolution, which it condemned with a large majority of 141 to 5 votes, with a number of abstentions of no-shows, the Russian invasion and aggression against Ukraine, and chose language that made it clear that this was not about dithering, but in terms of the choice of language, labeled it as an aggression for what it is. So it took a position that was probably firmer than some would have expected on the point of principle, and was supported by probably a number of states that was larger than had been anticipated. Now, I think the jury is out on whether you should look at this as a vote of 141 against 5, or whether you should focus on the abstention by states that are large in number, that are large in population, India, China, and others. So that is a question for what to make of that diplomatic effort. But you wanted me to speak about the impact of that, Neha. And I think on that respect, I think I see two functions. One is the General Assembly is powerful, and if we compare to the aspects we've been discussing before, more significant as a provider, dispenser, and umpire on questions of legitimacy. So the statement from the General Assembly, even if it doesn't link up with immediate concrete sanctions or actions that follow from it, is significant as a restatement of the point of principle. And I think it carries significant weight because of that. The other element is that the General Assembly resolution, having restated and having declared as unequivocally unlawful the Russian aggression, the statement could be relied upon by states that do what Emanuela has described, take sanctions and seek to justify their conduct where it goes beyond the level of a retortion. So these states looking for a justification may point to the General Assembly as having clarified the point of principle. that we not have to deal with a situation where there's a gray area of uncertainty about whether what Russia does is plausible or just somehow justifiable, or whether there could be sort of two sides to that view, but the General Assembly has made a very clear pronouncement. So this could have a legitimating function for sanctions that others are taking. If I may, Neha, just briefly, there's one field within international institutions which sort of straddles the private-public boundary. I think that some of you have spoken to, where something like a signal coming from the General Assembly is felt particularly clearly, and that's the world of sports. It's just one example among many, where we also have global sports, an international, institutionalized, highly centralized field, where you might say the issues are of symbolic relevance more than anything else, but are of high symbolic relevance. So Russia's position and the position of Russian teams and sporting bodies has been significantly affected in the follow-up to this crisis. And I think, Neha, you asked in opening whether we're seeing sort of continuity shift or ruptures. I think in the positioning of global sporting bodies, we see a significant shift away from this naive and cheap myth that sport is apolitical and has to stay above the fray, to the point where the global sports bodies, after some hesitation and after some dithering initially, have now broadly joined the movement, showing some level, perhaps not enough, but some level of solidarity with Ukraine, and have taken significant measures against Russian association, Russian teams, and Russian athletes. These are measures that are controversial if you look at the sporting regulation in and of itself, because of this myth of apolitical sports, but also because, of course, Russian teams and athletes are sanctioned for conduct of their state, not their own conduct. But I think they're defensible, because sporting bodies do not exist in a vacuum. For example, in sporting statutes, there's constant reference to the value of sports to the furtherance of peace. Now, in this setting, this cries out, in my view, for sort of adopting measures against sporting athletes. But to come back to the initial point on which you asked me, Nehan, I would say statements of principle that are clearly worded, even where they're devoid of sanctions, such as the General Assembly resolution, are legitimating and push and nudge sporting bodies to adopt more robust action than they would have otherwise have done. So I think we see an interplay between the institutional interstate world of diplomacy and the more difficult to position public-private world of global sports governance. Thank you.
Thanks for that, Christian. And of course, words matter, and symbols matter, especially high-profile symbols matter, whether they're coming from the public-private nexus or from the General Assembly. But in the second round, let's try and dig deeper into the impact of them, these individual legal and non-legal strategies that we've seen, and try and focus more closely on some of the more concrete and ongoing actions which have been taken by various institutions and their impact. Both the immediate impact on the invasion, but also the more medium and long-term impact on the institutions themselves. And here, as a few of you have already alluded to, one of the most high-profile interventions we've seen has been by the International Court of Justice. Last week, it issued its order on provisional measures in the case brought by Ukraine against Russia under the Genocide Convention. Judge Yudkivska, you'd mentioned the case initially. Could you reflect on the case and some of the legal dimensions, how it came about, and what was Ukraine hoping to achieve through bringing this case?
Well, yeah, thank you. Actually, what I meant, I didn't mean interim measures pronounced last week by the International Court of Justice. I meant measures pronounced by my court on 1st March and then continuing on 4th March. Now, very briefly on the measures by ICJ, they are unprecedented, really. It never happened in the history. But when we say, well, actually, I will now come to the European Court of Human Rights, and I will also say that it's also unprecedented. But of course, we should keep in mind that everything which is going on now did not have any precedent after the World War II. So we should really keep this in mind. Unprecedented situations require unprecedented decisions. So, of course, we all know, well, Russia did not even appear before the European Court of Justice. So you have seen these pictures with empty chairs. So they didn't plead. And basically, as the International Court of Justice ordered Russia to cease military activities, and of course this order would not be complied with and was not complied with, as we already see. And of course this opens the door for Ukraine to to use Article 94 of the Charter and to go to the Security Council, because Russia failed to enforce decision. Now, again, it is questionable from legal standpoint if it is if Article 94 covers the interim measures, and this is to be decided, and then to which extent we can use paragraph 3 of Article 27 of the Charter, meaning that Russia cannot vote in the Security Council being a party to the conflict. But there are legal doors now which are open for Ukraine to proceed, and it's really the meaning of this decision is hardly to overestimate. Now I come back to my cup of tea, to the European Court of Human Rights, and also I can tell you that on 1st March of 2022, the court requested, the court applied interim measures in the case submitted by Ukraine concerning this recent aggression, which started on 24th of February, and contrary to the ICJ, where it's absolutely unprecedented, for the European Court, we can say that we did have some precedents. Rule 39 was applied in the context of military activities in cases of Georgia versus Russia, Ukraine versus Russia, both Crimean and Donbass cases, so previous cases, and also the most recent one, Armenia versus Azerbaijan and Armenia versus Turkey cases. But if you compare the scope and the language used, you will see that the current interim measures is absolutely, significantly different. First of all previous measures were addressed to all parties concerned, all parties involved into the conflict, meaning Russia, Georgia, Ukraine, Azerbaijan, Armenia, and even Turkey in the latter case, which is of course understandable because we know, while we are human rights court, we deal with human rights, and all military activities by all the parties to the conflict may potentially give rise to a risk of a serious violations of rights of civilian population. But in the present case, interestingly enough, the interim measure was indicated to the aggressor only, and that's very significant for this court. Second, if in previous cases, the measures were very laconic, the court merely called upon contracting states to refrain from taking any measures, in particular military actions, which might entail breaches of the convention, the current measure is far more explicit. So here the court said that the Russian government should refrain from military attacks against civilians and civilian objects, including residential premises, emergency vehicles, other specially protected civilian objects as schools and hospitals. So the European Court was extremely precise in comparing to the previous interim measures applied. And then in 2 days, in response to a number of similar requests for interim measures from individuals, those who were, and again the court referred to them, those who take refuge in shelters, houses, and other buildings, fearing for their lives due to the ongoing shelling and shooting, without or with limited access to food, health care, water, sanitation, electricity, and other interconnected services for survival. So the court said that they are now covered by the measures, this general interim measure applied in the case Ukraine versus Russia. And moreover, the court expanded this measure and indicated to the government of the Russian Federation only that they should ensure unimpeded access to the civilian population, to the safe evacuation routes, healthcare, food, and other essential supplies. Of course, it would be too naive to believe that the humanitarian corridors announced immediately after had any causal connection with the interim measure applied, but still it's important. It's a sign that the European Court requested clearly in this case the humanitarian corridors. And what is also interesting, this is the first interim measure applied by the European Court in the context of the military conflict after in January 2021, the European Court pronounced a judgment in the case Georgia versus Russia 2, in which by majority of 11 votes, the Grand Chamber decided that the European Convention does not apply to the active phase of military hostilities. I voted against this decision. I wrote my separate opinion on that, but it's very interesting. So there the court said, sorry, military phase, active military phase, the war convention does not apply. And here, regardless, again, it's the first case, even, well, Armenia and Azerbaijan versus Azerbaijan was examined just 1 month before the court delivered. So it's the very first case on military operations delivered after Georgia versus Russia 2. So it's very, very interesting that, again, regardless, the court clearly found convention not to be applicable to the situation of the armed conflict. Here the court applied very strong and strict and severe Rule 39 interim measures. Again, of course, they were not complied with, but the case is yet to be examined. And of course, a clear violation of interim measures prescribed by the court will be examined as well. Thank you.
Thank you. So we see a court engaging in conflict litigation with an unprecedented set of measures. The other court is, of course, the International Court of Justice, and unprecedented, at least in terms of its speed, the provisional measures decision, but also perhaps unprecedented in other ways. Christian, you've written on conflict litigation and the ICJ. What would you say about the ICJ provisional measures decision?
Yeah, I think if you want me to point it in terms of precedented versus unprecedented, then I think twice unprecedented in one way, part of a broader trend, the ICJ decision that we've seen. So twice unprecedented, I mean, I think the point has been made by Anna. I mean, the ICJ order is unprecedented in its directness, specificity, and scope in terms of ordering Russia in no unclear terms to suspend all military operations. That is unusual for court orders bearing on military conflict. Second element is this is unprecedented because the decision was direct and specific, even though the jurisdictional basis for the ICJ to render such a decision was by no means clear. And this is what separates the two courts that Anna has spoken about, the ECHR and the ICJ. The ICJ's jurisdictional mandate is often a matter for contention. The jurisdiction is consensual. And in this case, there was only one treaty that could form the basis of the application that Ukraine brought to the ICJ. That was the Genocide Convention. So the argument was somewhat creative, let's say. Ukraine argued that Russia accuses Ukraine falsely of committing genocide in the Donbass and Luhansk regions, uses that as a pretext for waging war, and because that is the basis, the war must stop. I'm simplifying. And the court largely went along with that. And that is, let's say, I would say that is perhaps a plausible construction of a jurisdictional title, but on the spectrum of plausibility, this is clearly on the expensive side. And perhaps this was captured by what Judge Benuna said in his declaration, that he said he felt compelled to vote along with the provisional measures order, but had doubts about the jurisdictional basis. So now, in one respect, this is not so unprecedented, because I think this is part of a wider trend of states using international courts as instruments or sites of contestation in military conflicts. This is not something that has started with this war, even though there are novel aspects to the Ukrainian litigation, but the idea of conflict litigation is at least 20, 30 years old. For a US audience, many say it has started either with the Tehran hostages litigation or with Nicaragua's litigation against the United States, where on the basis of a military conflict or a geostrategic conflict, players seek to use international courts to shift the public perception of the conflict. We've seen this in the Yugoslav wars. We're seeing it between Armenia and Azerbaijan. We're seeing it in many more conflicts. So in that respect, the Ukraine-Russia litigation that has been before the ICJ is just part of a wider trend of conflict litigation. And we still have to observe whether that trend takes us. Many thanks.
So some old tools, some new tools, some continuing tools, so a rethinking of some of the more conventional tools that we see by both the European Court as well as the ICJ. But let me get back then to the other tool that we discussed in the first round, which is the tool of sanctions. And Emanuela, you sort of hinted at this, that sanctions, in this case, are the sanctions proportionate? Are they targeted? And one of the reasons for this is probably also because they've been such a controversial tool in the international legal order in the past. They've been criticized for not being targeted enough or not being nimble enough to meet their objectives. In this case, though, do you see the sanctions, or at least the kind of sanctions that have been imposed so far, actually having the capacity to respond to the humanitarian needs of the conflict?
Thank you. And so my question is more focused. My analysis is, can these sanctions impact the capacity of humanitarian actors to respond? And this is a narrower question of than the humanitarian impact of the sanctions more broadly. And it's been evident for a number of years that even targeted sanctions can affect the capacity of humanitarian actors to operate. This is most notably the case if the sanctions designate groups that exercise governance role, such as the Taliban, Hamas, Al-Shabaab. There's a very clear risk that incidental payments that humanitarian actors may have to make in the course of their operations fall within the prohibitions. Assistance that's diverted falls within the prohibition on making funds or assets available. But, and this is also the problem in relation to the Ukraine sanctions, it could also be private actors with whom humanitarian actors are going to need to engage, to transact, that are covered. In other contexts, it was telecoms providers or airlines, or trade restrictions. So, for example, the EU sanctions prohibit the purchase of petroleum products in Syria, very clear impediment to humanitarians to be able to operate. So it's been evident that we do need to have adequate exceptions in place that exclude either funds or assets provided in the course of humanitarian activities from the scope of financial sanctions, or adequate safeguards to trade restrictions, such as the purchase in fuel. Where do we stand in relation to Ukraine? And I was actually on a phone call just before this panel to try and determine exactly what are the likely points of friction in relation to Ukraine. How do they affect the response in Ukraine and in neighboring states? Now, as I said, we're not starting from zero. There already were some sanctions in place, and in particular, the two de facto authorities, the two republics, were themselves designated under financial sanctions imposed by the EU and the US. This precluded making funds available to them, even though they were exercising a governance function. So how do we deal with taxes, licenses, permits, the very questions we were asking in relation to the Taliban? The US provided a special license for some humanitarian actors operating in those two republics. The EU gave nothing. So we were already in a delicate position. What about the most series of restrictions? As I said, it's unclear yet exactly to see what it is, but what are the likely problems? I think that there might, in view of the very, very broad number of designated private actors, transport companies, aircraft, vendors, suppliers that are owned by designated individuals that play a role in the chain of procurement, humanitarian actors might have a problem. They might need to make a payment or rely on the services of an entity that's designated. There are restrictions on imports of certain dual-use items into the two republics that also cover materials that humanitarian actors might need for their programming. At present, there's only the possibility of obtaining licenses as opposed to an outright exception. Processes for obtaining licenses need to be sped up. I think it's the measures in relation to the broad range of financial restrictions that are also going to cause problems. Much of the emergency response is in the form of cash programming, which doesn't actually mean you're going to give money. It's through credit card companies. Are they going to be willing to carry out activities if it's unclear whether they might violate sanctions? But it's also important to bear in mind we have reverberating effects way beyond Ukraine and neighboring state. For example, imports of wheat into Afghanistan from a neighboring republic were paid in rubles. It's now prohibited to use rubles. We see this cascading effect. There's also the risk averseness of banking sector generally to engage in anything that could give rise to a violation of sanctions. This is going to affect the capacity of humanitarian actors to operate. What do we see at present? The US has adopted 2 general licenses covering the activities of UN, ICRC, Federation, and NGOs, but only in the 2 republics and in other parts of Ukraine to be determined. What about neighboring states? What about third states? It's really such a broad range of designations and financial sanctions that it needs to be broader. The UK operates by means of licenses, so you need individual authorizations. That's not going to be fast enough. It's not going to be nimble enough to respond. I don't think there was any impact assessment conducted before the imposition of these sanctions. And as you said, Niha, it's important that the states, the organizations imposing the measures stand ready to refine them, to render them more nimble, to allow humanitarian action as the problems become evident.
Thank you. So a lot of we've discussed so far, most of what we've discussed so far has been in the form of legal action, naming and shaming, expulsion, exile, all of which are important strategies, both legal, private, public, informal. But and maybe this is the American in me who wants to see the brighter side. But I was wondering if there's any space left in all this for actually constructive engagement or constructive cooperation in this very, very difficult situation. Perhaps I can, we started with you, Tess, and perhaps we can close with you as well on this very difficult question. Do we have any space that remains for constructive cooperation?
It's a really important question. I'm not sure how rosy I'll be about any of the paths forward for the international order, but I think we have to try to start addressing exactly that issue. There are bad scenarios, and then there are worst case scenarios for long-term global stability. And we need to start thinking now about how to avoid those worst case scenarios. So just a few points to consider in the time we have. One is that it's quite clear that diplomatic isolation, harsh sanctions, these are appropriate short-term consequences for Russia, but start extending those tactics out over the long term and thinking about what kind of strategy they're embedded in. And we start to see, methods that haven't worked so well in the past. So when you think about DPRK, when you think about US-Iran relations or US-Cuba relations, did we see isolation and harsh sanctions against a rogue regime change their behaviors in a way that those tactics were aimed at trying to change? No, we didn't. In fact, we saw the opposite. We saw hardening into their corners, right? We saw states, in fact, being willing to double down when they're acting on their perceived vital national security interests. So I think one of the things we have to think about on the front end is what is the long-term strategy, even if these measures make a tremendous amount of sense in the short term, while we're trying to see, how can we most effectively try to get Russia to stop the violence. One of the things that has been floated, of course, is kicking Russia off the UN Security Council. That's very tempting, although probably unworkable legally and practically. But even if it were something that were workable legally and practically, then we also have to think about, what is the long-term consequence for the global order of having political upheaval, potentially violence in a destabilized nuclear superpower that remains on Ukraine's doorstep. Right? Is that actually better? And does it function as a way for the international community to limp forward? So these are some of the worst case scenarios to avoid. But I just also in a short time we have want to flag, there could also be concrete benefits to trying to find areas of cooperation. So even when US-USSR tensions were at their height during the Cold War, during proxy conflicts, when nuclear tensions were very high, they found ways to cooperate on nuclear nonproliferation in particular, on stopping the spread of nuclear weapons, on limiting the use of certain kinds of arms. Those are the kinds of things that it will take time to climb back out of the hole we are in. But I think we have to start now thinking about what that long-term trajectory looks like in order to build the conditions where we can find cooperation on some of those most pressing issues. The global order will not benefit from shying away from looking for those areas of cooperation, even though Russia needs to continue to face costs for its aggression. So that balancing act, I think, how do we stop the violence, cease the suffering in the short term, hopefully as soon as possible, but how do we think forward to what the global order looks like with an aggrieved and isolated nuclear superpower that remains on Ukraine's doorstep? Those are two things that could be seen to be in tension, and that I think we need to pay a lot more attention to as we start to shift towards looking at a long-term strategy.
That's great, thank you. And I see we're out of time. We could, of course, continue for at least an hour more on these themes, but I think we have to end here. So thank you again to all of you for having participated in this panel. I think we all learned a lot. I think the invasion is one of those episodes that in some way it has to await the future to learn its own meaning. But you've all helped us at least navigate our way through these past few weeks and months, but also through the future that we will all see. So thank you again very much for joining us. Thank you to all our participants. And yes, we hope to see you again for another event in more pleasant circumstances. Thank you again.
Thank you.